Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. అందరికీ శుభోదయం. ఈ వీడియోలో the important point to discuss is, even though motive could not be established, if there is enough circumstantial evidence, conviction will be sustained. Normally, we are under the impression that motive is an essential part to commit a crime. While discussing the topic of actus reus, I told you that there should be intention, motive, preparation, attempt, and ultimately the act. Sometimes, when the motive is not clearly established, but if there is clinching circumstantial evidence, res geste, Section 6 of the Evidence Act, it's enough to give conviction. This is what is stated by Honorable Justice Sudhanshu Dhulia and K. Vinod Chandran of the Honorable Supreme Court. In the case of Subhash Agarwal versus State of NCT, National Capital Territory Region, Delhi, SLP number 1069 by 2025, decided on 17/4/2025. They observed that absence of motive does not ipso facto be detrimental to the crime. It is not fatal if there exists a strong circumstantial evidence against the accused or to bring home the guilt of the accused. Now, this is a case which was first given as a case of suicide. It was altered to 302 IPC. It all goes beyond a family, between a family. The father, Subhash Agarwal, on the intervening night of 14/15/2012, 2012, అది అర్ధరాత్రి, at about 12:45 a.m., he started shouting that his son has committed suicide, his son has shot himself, కొడుకు తుపాకీతో కాల్చుకున్నాడని, స్క్రూ డ్రైవర్తో పొడుచుకుంటున్నాడని కేకలేస్తున్నాడు. This Subhash Agarwal is having a wife and 4 daughters besides this boy. This boy is the youngest man. Deceased was the youngest boy. 2 daughters were already married and they were living separately. 2 daughters are sleeping along with his wife. అండ్ కేకలు వినపడి అందరూ అక్కడికి వెళ్ళారు. వీడు రక్త మడుగులో పడుకున్నాడు పిల్లాడు. ఇమీడియట్లీ దే కాల్డ్ ద నైబర్స్ ఆల్సో. ఆల్ ఆఫ్ దమ్ కేమ్ అండ్ సా. ఎనివే, ద రిపోర్ట్ టు ద పోలీస్ వాజ్ యాజ్ దో ద డిసీజ్డ్ షాట్ హిమ్సెల్ఫ్ అండ్ కమిటెడ్ suicide. But police, they have done the investigation in their own fashion. Ultimately, of course, then they contacted the relatives or the wife and others. They said that there are no strained relations between the boy and father. All of them are very good, having very good relations. Wife and others also stated that there are no strained relations in the family. Then, what is the motive? Police altered the section into 302 IPC and charged him under 302 of the Indian Penal Code. 302 as well as section 27 and 28 of the Arms Act. And he was convicted. The pity. So the police charged him under 302 because they did the investigation, they know well. And he was convicted. Now he has come to the Supreme Court against the as a sort of appeal. The main point here is the police found GSR, that is gunshot residue, on the right hand of the accused person. What is gunshot residue? When you fire a person, normally if you hold the barrel like this, if the weapon goes, నార్మల్గా దీంట్లో రికోషిట్స్ అని కొట్టినప్పుడు కొంత స్మోక్ కానీ ఈ డస్ట్ కానీ డిపాజిట్ అవుతుంది. దట్ ఈస్ కాల్డ్ గన్ షాట్ రెసిడ్యూ. అది దొరికింది. Of course, the defense lawyer says that police have forcibly asked him to fire. ఇంకోటి ఏదో చేశారు, దానివల్ల గన్ షాట్ రెసిడ్యూ వచ్చినాడు. We don't know whether it is correct or not. ఆ పాయింట్ కూడా దీనిలో తీసుకొచ్చారు. But anyway, the GSR is found on the right hand of the accused. Second, the post-mortem examination. It says that he died of hemorrhagic shock as well as heavy loss of blood is quite common due to firearm from the close range. Firearm from the close range. సూయిసైడలు లేకుండా బయట నుంచి కొడితేనే డెఫినెట్గా తేడా ఉంటుంది. సూయిసైడ్ రైట్ హ్యాండ్ అయితే ఇక్కడే పెట్టుకుంటారు. బట్ వాట్ ఎవర్ ఇట్ ఈస్, అది కూడా పిఎం సర్టిఫికేట్లో ఇట్ హ్యాస్ బికమ్ ఎ సబ్జెక్ట్. అండ్ డిఫెన్స్ క్లియర్గా చెప్పారు, జిఎస్ఆర్ ఆన్ రైట్ హ్యాండ్ ఇట్ థ్రోస్ లాట్ ఆఫ్ డౌట్. పోలీసులో చేసి ఉంటారంటారు. And police rubbed his hand with the so-called GSR. Right. It is a suicide. Then, if you say that is suicide, what is the motive? They are not able to tell. If it is a murder, what is the motive? They are not able to tell. రెండు చెప్పలేకపోతున్నారు. కానీ the intermittent facts, the persons who have seen, immediately వచ్చిన వాళ్ళు వీడు బ్లడ్లో కొట్టుకుంటూ ఉన్నాడు, ఫాదర్ కేకలేసాడు, క్లోజ్ షాట్, ఇవన్నీ ఉన్నాయి. కాబట్టి డెఫినెట్లీ ఫాదర్, అది కొన్ని సందర్భాల్లో అందుకే అంటారు ఇంట్లో దొంగ ఈశ్వరుడు గారు, కానీ వాళ్ళు ఏమన్నాయో తల్లి చెప్పలేదు కొడుకు మీద, భర్త మీద చెప్పలేదు, చిల్డ్రన్ కూడా అదే పరిస్థితి. సో దేర్ ఫోర్ ది పోలీస్ దే హ్యావ్ ఇన్వెస్టిగేటెడ్ ద కేస్ మెటిక్యులస్లీ. నో డౌట్ దెర్ ఇస్ నో motive alone. Motive could not be established clearly in this case, but enough circumstantial evidence, enough res geste, enough section 6 of Evidence Act is there. So therefore, basing on a couple of important cases like Nandu Singh versus State of Chhattisgarh 2022, State of UP versus Krishnapal 2008. So Honorable Supreme Court said that the appeal is not allowed. When the circumstantial evidence is sufficient, it is enough to bring hold the guilt of the accused and he can be convicted. Conviction sustained. So this will be useful for the prosecution. So please read the case law and enrich your legal knowledge. Thank you.